Very good morning, friends. Today, we deal with Article 16 of the Constitution of India, which provides equality of opportunity in matters of public employment. Clause 1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Clause 2. No citizen shall, on the grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for or discriminated against in respect of any employment or office under the state. Clause 3. Nothing in this article shall prevent the Parliament from making any law prescribing in regard to a class or classes of employment or appointment to any office under the government of or any local or other authority within the state or union territory, any requirement as to residence within the state or union territory prior to such employment or prior to such appointment. Clause 4. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward classes of citizens which in the opinion of the state is not adequately represented in the services under the state. Clause 4a. Nothing in this article shall prevent the state from making any provision for the reservation in matters of promotion with the consequential seniority to any class or classes of posts in the services under the state in favor of the scheduled caste, scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. Clause B, 4b. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with the provision for reservation made under Clause 4 or Clause 4a as a separate class of vacancies to be filled up in any succeeding year or years, and such class of vacancy shall not be considered together with the vacancies of the year in which they are being filled up for determining the ceiling of 50% reservation on total number of vacancies of that year. Now Clause 5. Nothing in this article shall affect the operation of any law which provides that the incumbent of any office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing particular religion or belonging to particular denomination. Clause 6. Nothing in this article shall prevent the state from making any provision for the reservation of appointment or posts in favor of any economically weaker sections of citizens other than the classes mentioned in Clause 4, in addition to the existing reservation and subjected to maximum of 10% of the posts in each category. Yes, friends, we have gone through the bare reading of Article 16 in full. Now, let us see some analogous laws in connection with Article 16. The Act of 1833, the Government of India Act 1915, the Government of India Act 1935 contained the similar provisions which are in Clause 2 of Article 16. Let us verify them. Section 298, subsection 1 of the Government of India Act 1935, which provides no subject of His Majesty domiciled in India shall on the grounds only of religion, place of birth, descent, colour, or any of them be ineligible for the office under the Crown in India. Now section 275 of the Government of India Act 1935. A person shall not be disqualified by a sex for being appointed to any civil service of or civil post under the Crown in India other than such a service or post as may be specified by any special or general order made. Yes, friends, there are clauses A, B, C, and also a provision annexed to section 275, which are unnecessary and irrelevant. So I feel it is a mere waste of time reading them, and they are omitted in this audio. Now, section 87 of the Act of 1833 contained the similar provision, friends. Now, section 96 of the Government of India Act 1915 1.5 also contained the similar provision as the provisions contained in sections 295, 290, and 275 of the Government of India Act, and also whatever it is contained in Article 16, Clause 2 of the Constitution of India. This article is a specific application of the general principle of equality contained in Article 14 of the Constitution of India, friends. Yes, like Article 15, this article also applies only to the citizens. Let us dwell directly into the Clause 1 of the Article 16. The words employment or appointment are wide enough to include tenure, duration, emoluments, and duties and obligations, whether employment is temporary or permanent. The equality of opportunity is a preambular promise by we the people of India to all the citizens of India, friends. The expression matters relating to employment or appointment. Yes, friends, it is not the word matter. It is the word matters, not a singular, but a plural is used. So it is matters relating to employment or appointment. What it means? The meaning of the matters relating to not only the initial appointments, the matters relating to prior to the appointments like examination fee structure, marks obtained in entrance examination for a post, etc. For example, OC candidate has to pay ₹500 for the examination for the employment or appointment. Similarly, BC has to pay ₹300 and SC has to pay ₹100, and there is no fee for physically challenged persons for the entrance examination for the post or employment. So these are the matters prior to the employment, not the matter relating to employment. It is matters relating to employment. Another example, the eligibility for an employment is OC candidates must get more than 60%, BC candidate must get more than 50%, SC candidate must get more than 40%, and a physically challenged person candidates must get at least 30%. So, this may be treated as matters relating to employment. With these two examples, I made very clear, lucidly clear, that the matters relating to employment or appointment prior to the employment or appointment. Yes, friends. And also matters relating to employment or appointment subsequent to such employment or appointment, like salary, increments, passing of departmental tests, promotions, gratuity, leave pensions, and age of superannuation, and travelling allowances like people like physically handicapped. So, these are the matters relating to employment or appointment subsequent to the employment or appointment. Yeah, once again I repeat and reiterate why it is the word matters, not the matter. Matters relating to employment అని అన్నారు కానీ matter relating to employment అని అనలేదు. Now, you may entertain a reasonable doubt that Article 16 provides equal opportunity in matters relating to employment or appointment. Then why these inequalities among the citizens belong to OCs, BCs, SCs and STs, physically disabled persons and women, etc. The matters relating to employment or appointment. I suggest you to remember Article 14. As I mentioned in Article 14, treat like cases alike, unlike cases unlike. Aristotle Nicomachean Ethics book. And equality among whom? Equality among equals is equality, not among unequals. So equals must be treated equally, unequals must be treated unequally. Treating unequal person with equals is discriminatory. So, OCs, SCs, STs, BCs, physically challenged persons and women are unequals. And there cannot be an equality among unequals. The true import of equality of opportunity is not simply a matter of legal equality. Its existence depends not merely on the absence of disabilities, but on the presence of abilities and opportunity of excellence in each cadre and grade. As equality among equals, not among equals. So, the reservation for physically handicapped persons lies in Article 16, Clause 1. Friends, why I may be permitted to read it once again. There shall be equality of opportunity for all citizens in matters relating to employment or appointment in any office under the state. These physically handicapped are unequals when compared to others. Hence, the reservations for physically challenged persons lies in Article 16, Clause 1 of the Constitution of India. And some eminent people like judges and lawyers misunderstand that the reservation for physically challenged persons is not a fundamental right. No, it is a fundamental right under Article 16, Clause 1. And it is not the option of the state. And it is mandatory to follow these reservations, which are horizontal reservations. Thank you, friends. Yes, friends. Clause 2 of Article 16 of the Constitution of India. No citizen shall, on the grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for or discriminated against in respect of any employment or office under the state. Yes, friends, here in this class 2, two words are very, very important. The first word is that only. On the grounds of only of religion or race, caste, sex, place of birth, etc. Only means what? Simply only means solely. That shows that class 2 applies where a citizen is held as ineligible for a certain public employment solely on the ground of his religion, race, caste, sex, place of birth, etc. And not his religion, race, etc. constitutes, but one of the factors that decide his eligibility for public employment. So, we have seen the meaning of the word only, which means solely on the ground of religion, race, caste, sex, place of birth, etc., etc., etc. Now the words any of them, indicate that the grounds of discrimination enumerated should not be made on the basis of discrimination either cumulatively or separatively. In other words, whether all the grounds mentioned exist together in a case or only one of them exists, no discrimination should be based solely upon them. The expression discriminate against, this is also very, very crucial word in understanding class 2 of Article 16 of the Constitution of India. The word discriminate comes from the Latin origin discriminare, which means divide, separate or distinguish. James Murray's New English Dictionary, published by Oxford Clarendon Press in the year 1897, volume 3, page 436, gives the meaning of the expression to discriminate against as to make an adverse distinction with regard to or to distinguish unfavorably from others. This is the meaning given in James Murray's New English Dictionary. Discrimination and preferences are twins, and they are inseparable ideas. Discrimination thus involves an unfavorable bias, and it is in that sense that the expression has to be understood in this context. Discrimination is a comparative in its connotation, friends. For example, discrimination on the ground of sex must mean that one sex is discriminated against the other sex. The discrimination is double-edged, friends. Article 16, Clause 2 brings out emphatically in a negative form what is guaranteed in Article 16, Clause 1. I repeat once again, Article 16, Clause 2 brings emphatically in a negative form what is guaranteed by Article 16, Clause 1. Why discrimination is a double-edged weapon, friends? It would operate in favor of a person, but not against some other. To understand this concept that is enumerated in Article 16, Clause 2, let us see one judgment. Janagiram versus State of Andhra Pradesh, AR 1959 SC 185. It has been held that the termination of employment of an employee on the only ground that he is non-Andhra is violative of Article 16, Clause 2. Because discrimination on the sole ground of the place of birth. With this illustrated case law, you may try to understand other grounds of discriminations that are given in Article 16, Clause 2, like religion, race, caste, sex of birth, descent to place of birth, residence, etc. Thank you, friends. Thank you so much. Yes, friends. Now let us discuss Clause 3 of Article 16. Nothing in this article shall prevent the Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the state or union territory any requirement as to residence within that state or union territory prior to such employment or appointment. Yes, friends, this provision has been made as an exception to the general rule enumerated in Clause 1 and Clause 2. Article 16, Clause 2 specifically forbidden the discrimination on the ground of residence. You have observed this and you heard about this. However, there may be good reasons for reserving certain posts in the state for the residents only. This Clause 3 of Article 16 empowers the Parliament alone and not the state legislature to regulate the law. At this juncture, I strongly recommend to read Article 35 of the Constitution of India. By virtue of the power under Article 35, read with Article 16, Clause 3, the Parliament enacted the Public Employment within the brackets Requirement as to Residence Act 1957, empowering the Government of India to prescribe residence as a condition for employment in certain posts and services in the states of Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. This exception for the period of 5 years only, according to the Act of 1957. And this Act has been expired in the year 1974. Now there is no provision for prescribing the residence as a condition for the public employment, except that for Andhra Pradesh, that is state of Andhra Pradesh, this special provision you will find in Article 371D. This Article 371D was inserted by the Amendment Act 1975. To achieve the primary object, Clause 1 of Article 371D empowers the President to provide by an order for equitable opportunities and facilities for the people belonging to the different parts of the state in the matter of education and public employment. In case of V.V. Reddy versus State, AR 1973, SC 827, the apex court of this land held that the Mulki rules continue to be in force after the formation of the state of Andhra Pradesh. Yes, friends, I forgot to tell you one important judgment. That is, Narasimha Rao versus State of Andhra Pradesh, AR 1970, SC 422, in which the apex court held that the residential requirement provided in the public employment, that is, requirement as to Residence Act 1957, is unconstitutional, which prescribed residence as a qualification for the government service in the state of Telangana area of the state of Andhra Pradesh. Why? Why Mulki rules are nullified by this judgment, that is Narasimha Rao versus State of Andhra Pradesh, AR 1970, SC 422. It has been observed by the apex court that the word state, that is Article 12 of the Constitution of India, used in Article 16 Clause 3, signifies the whole state and not the part of the state, that is Telangana. So therefore, the residential qualification can be prescribed for the whole state and not for the part of the state, that is Telangana or Uttarandhra or Rayalaseema, etc. Though the parliament can reserve certain posts in Andhra Pradesh for residents of the state, however, the Supreme Court left open the question whether, in view of the constitutional invalidity of this act, the Mulki rules existing in the state of Telangana area could be said to be continuing in force by virtue of Article 35, Clause B of the Constitution of India. Yes, friends, I again strongly recommend you all to read Article 371D of the Constitution of India. Thank you, friends. Yes, friends, Clause 4 of Article 16 of the Constitution of India. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any backward classes of citizens which is, in the opinion of the state, is not adequately represented in the services under the state. So, this provision provides socio-economic equality to the disadvantaged. The expression backward classes of citizens contained in Clause 4 of Article 16 would take scheduled castes, scheduled tribes within its purview and meaning. It is to be noted that the reservation is to be made after taking into consideration of the efficiency of the administration under Article 335 of the Constitution of India. In Balaji versus State of Mysore, AR 1963 SC 649, it has been observed that the Article 16 Clause 4 applies only if two conditions are satisfied. The first condition is the class of citizens is backward, which means they must be socially and educationally backward. They must be socially and educationally backward. Second condition, the said class is not adequately represented in the services of the state, and this second condition or second test alone cannot be a sole criteria for giving reservations. In case of Janaki Prasad versus State of Jammu and Kashmir, AR 1973 SC 930, the apex court of our land held that in order to be identified as belongs to backward classes, one must be both educationally and socially backward. The social backwardness itself or the educational backwardness itself does not itself make a class of citizens of backward. What I mean is, to identify particular class of citizens as backward classes, they must be socially and educationally backward. In the case of Devadasan versus Union of India, AR 1964 SC 179 held that Clause 4 of Article 16 is an enabling provision and confers a discretionary power on the state to make reservations of appointments in favor of the backward classes of citizens, which is, in the opinion of the state, not adequately represented, but it is not itself is a fundamental right. I do not personally agree with this opinion that is expressed in this judgment. Why? Because show me a single fundamental right in Part 3 of the Constitution of India, which is an absolute fundamental right, which is without any limitations and without any conditions. Every fundamental right in Part 3 of the Constitution of India is subjected to certain conditions and limitations. If so, why this particular clause, that is Clause 4 of Article 16, is not a fundamental right, and why other fundamental rights are fundamental rights, is my simple and straight question to the audience. In case of C.A. Rajendran versus Union of India, AR 1978 SC 507, it has been held that it is open to the state to withdraw the benefits conferred on the scheduled castes and scheduled tribes, and they have no remedy in any court of law. The state has an absolute power to withdraw the reservations, and the scheduled castes and scheduled tribes have no remedy in court. No, I do not agree with this judgment. In case of K.C. Vasantakumar versus State of Karnataka, AR 1985 SC 1495, it has been suggested that reservation in favor of the backward classes must be based on means test. It has been further suggested that the policy of the reservation should be reviewed for every 5 years, or if the class has been reached up to the level where it does not need a reservation, its name, that particular caste or tribe name, can be deleted from the list of the backward classes. The General Manager, Southern Railway versus Rangachari, AR 1962 SC 36, it has been held that while Article 16 Clause 4 is apparently without any limitation upon the powers of the reservations conferred by it, it has to be read together with the Article 335, which enjoins that in taking into consideration the claims of the scheduled castes and scheduled tribes in making appointment in connection with the affairs of the state or the union, the policy of the state should be consistent with the maintenance of efficiency of the administration. In Trilokanath versus State of Jammu and Kashmir, AR 1969 SC 1, the Honorable Supreme Court disapproved the reservations in favor of the castes and communities like backward Hindus, backward Muslims, backward Christians, etc. The expression backward class used in Article 16 Clause 4 cannot be accepted to mean it is backward caste or the backward community. A backward class of citizen in the context of Article 16 Clause 4 means a member of socially and educationally backward classes of citizens. Article 16 Clause 4 has been thoroughly examined by the Supreme Court in the historic case of Indrasena versus Union of India, AR 1993 SC 477. This is popularly known as the Mandal case. On 1st day of January 1979, the Government of India appointed a commission under the chairmanship of B.P. Mandal under Article 340 to investigate the socially and educationally backward classes within the territory of India. The Commission submitted its report on 31st day of December 1980. The report was not implemented till July 1990. The Commission identified 373 castes as socially and educationally backward classes. The Commission recommended 27% of seats in the government services in addition to those already reserved for scheduled castes and scheduled tribes. Accordingly, the Government of India, headed by the Prime Minister, the then Prime Minister, V.P. Singh, issued an official memo on 13th day of August 1990. Thereafter, the government, headed by Mr. P.V. Narasimha Rao, issued another official memo on 25th day of September 1991, bringing two changes. The first change is by introducing economic criteria in granting the reservation by giving preference to the poorer sections of socially, educationally backward classes in the 27% quota. Second condition, reserved another 10% of vacancies for another socially and educationally backward classes, that is SCBC, economically backward sections of higher castes not covered by any of the existing schemes of reservation. The second change, that is reservations for economically backward classes of higher caste, was struck down by Honorable Supreme Court as it is unconstitutional. The majority of the judges held that the reservation should not exceed 50% of the total reservations. Article 16 Clause 4 is not exception to the Article 16. Article 16 Clause 4 is an instance of classification of Article 16 Clause 1. Article 16 Clause 4 permits the classification of backward classes into backward classes and more backward classes for the purpose of giving more protection to more backward classes. Reservations under Article 16 Clause 4 cannot be made in promotions. This is the finding in Indrasena versus Union of India, AR 1993, SC 477. The reservation confined to initial appointments only. If the reservation in promotions exists, it shall continue for 5 years, that is till the 16th day of November 1997. Hence, however, by 77th Amendment Act 1995, this limitation of time, that is 5 years, has been removed by inserting Clause 4A to enable it to continue the reservations in promotions for scheduled castes and scheduled tribes. Next, we are going to see Article 16 Clause 4A. Yes, friends, Clause 4A. Nothing in this article shall prevent the state from making any provision for the reservation in matters of promotion with the consequential seniority to any class or classes of posts in the services under the state in favor of the scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. The Constitution 85th Amendment Act 2001 has substituted this clause 4A for the words in matters of promotion to any class and the words in matters of promotion with the consequential seniority to any class. So, this amendment aims at extending the benefit of reservations in favor of the scheduled castes and scheduled tribes in matters of promotion with the consequential seniority from April 1995. The constitutional validity of this clause, that is Clause 4A, was challenged in case of M. Nagaraju versus Union of India. The court upheld its legality by stating that this provision is in line with Article 16, Clause 4. However, to protect the misuse of this Clause 4A, the court evolved the doctrine of proof of compelling reason. This doctrine means that every time the state wants to make a reservation in the matters of promotion, it must demonstrate that the scheduled castes and scheduled tribes are not adequately represented and there is a strong need for the reservations. With this, I end the discussion on Clause 4A. And now Clause 4B. Nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up in that year in accordance with the provisions for the reservation made under Clause 4 or Clause 4A as a separate class of vacancies to be filled in the succeeding year or years, and such class of vacancies shall not be considered together with the vacancies of the year in which they were being filled up for determining the ceiling of the 50% of the reservations and total number of vacancies of that year. This clause was incorporated through 81st Amendment Act in 2000, which seeks to end the 50% of this ceiling reservation for SCs and STs and BCs in the backlog vacancies which could be filled up in the previous year due to non-availability of the eligible candidates. Yes, friends. In other words, these vacancies will not be taken into consideration which computing the totality of the 50% of the reservation limit. The constitution of this clause was upheld in the landmark judgment in case of M. Nagaraju versus Union of India. Now, Clause 5. Nothing in this article shall affect the operation of any law which provides that incumbent of any office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to particular denomination. This clause is the non-obstante provision, friends, that overrides all other previous provisions contained in Article 16. The provision states that no law will affect the appointment in any office that is connected with some religious or denominational institution. This Clause 5 empowers to appoint any person who is professing that particular religion or related to that religious denomination. In the case of TMF Pai Foundation, State of Karnataka, the Honorable Supreme Court held that the Clause 5 of Article 16 cannot be enforced in private unaided educational institutions and in other religious minority institutions. Yes, friends. Now, Clause 6 of the Article 16 of the Constitution of India. Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes mentioned in Clause 4, in addition to the existing reservations and subjected to maximum of 10% of posts in each category. This is the constitutional amendment of 103rd, which incorporated clause 6 of the Article 16 of the Constitution of India. This clause allows 10% of reservation of a maximum, that is 10% for the economically backward classes or economically weaker sections in the public employment. The NGO by name Youth for Equality challenged this clause. At that time, I was in Delhi and also suggested in draft of the writ petition, and it was challenged. This clause is violating the 50% of the reservation rule laid down in Indrasena versus Union of India. The court refused to grant a stay on this reservation, that is 10% of reservations for the economically weaker sections of the public employment, as this section will be in addition to the existing quota of 50% of reservation limit. With this, I end Article 16 successfully.